these fundamental rights are not absolute. They are not absolute. So they can be restricted. There are certain constitutional conditions, right? That is, our constitution has laid down certain conditions, right, wherein which if they are violated, if that conditions are violated, then the fundamental rights can be restricted. Right? Say for example, right, in Article 19, Clause 2, right, there are certain conditions mentioned. Article 19, Clause 2, there are certain conditions mentioned for enjoying the freedoms of individual. So whenever these conditions are violated, so it can be a ground for imposing restrictions on individuals. All right, restrictions on the rights of individuals. Not only this, all right, by using a law of parliament, by using a law of parliament, right, this restrictions can be imposed. Right. So in the last class, I have talked about arbitrary restrictions. So when restrictions imposed will be called as arbitrary in nature. When these restrictions will be called as arbitrary in nature. All right. So when restrictions are imposed without a law, then all such restrictions will be regarded as arbitrary. So whatever the restriction that is imposed, it should be according to law, right? And it should be purely based upon the grounds mentioned in law, right? So when restrictions are against the law or contrary to the law, then they are regarded as arbitrary in nature. All right. Next one. All right. Now the issue is, who has the power to impose restrictions? Now, who has the power to impose restrictions? So it is the state. State has every power. To impose restrictions. State has the power. To impose restrictions on the rights of individuals. All right. So fundamental rights can be restricted. They are restricted when constitutional conditions are violated or a law is violated, and state has every power to impose restrictions. All right. So now when we use the word state, which organ of the state has the power to impose restrictions? Which organ of the state has power to impose restrictions? All right. So normally, all right, we have executive, legislature, and judiciary. Out of these three organs, which has the power to impose restrictions? Can you remember in the class?
Legislature.
Okay. So primarily it is executive. So executive has the power to impose restriction. That is the elected government of the day. It is the government of the day which has the power to impose restrictions. But every restriction that is imposed by executive should be according to law, should be according to procedure established by law. All right. So every restriction, so it is primarily the executive, but every restriction that is imposed by executive should be according to law. It should be according to law, and it should be according to procedure established by law. Right? It should be according to procedure established by law. Right? So this is clearly mentioned in the Constitution. Right? The doctrine, the concept of procedure established by law is clearly mentioned in Constitution. That means whether executive can act without a law, whether executive can act without a law. So executive cannot act without a law. Every act of executive should be according to law. Now imagine a situation where executive acting without a law, then can we call such acts of executive as arbitrary acts? Can we call such acts, that is executive acting without a law, so can we call such acts as arbitrary acts? Yes or no? So remember, whenever executive acts without a law, then all such acts will be regarded as arbitrary acts. All such acts will be regarded as arbitrary acts. They have no validity. That means restrictions imposed by executive without a law, right, have no validity. They can be simply regarded as unreasonable and arbitrary restrictions. All right. So whenever the executive acts without a law, then such acts will be regarded as arbitrary acts, and they have no validity. Such restrictions have no validity. So remember this point. Right? So though executive has the power to impose restrictions, but every such restriction should be according to law prescribed by legislature. Alright? If executive acts without a law, then such acts of executive will be called as arbitrary acts, and courts can strike down all such acts of the government. Alright? So, and this was clearly said by Supreme Court in A.K. Gopalan versus State of Madras case. It was in A.K. Gopalan versus State of Madras case. Alright. So this is very, very important case. Alright. So it was in this case, Supreme Court held that every restriction imposed on the rights of individual should be reasonable. Alright. So the concept of reasonability of restrictions. It was first upheld by Supreme Court in A.K. Gopalan versus State of Madras case. Not only this. Now who should check whether the restrictions imposed are reasonable or not? Who should check whether the restrictions imposed are reasonable or not?